this lecture, we are going to discuss about another topic, which is abuse of legal procedure. Now, what is abuse of legal procedure is when you use the machinery of justice to cause some hardship to another person. The law has given power to people to file cases against them or to file complaints to attain justice. However, if you use this machinery to harass somebody or to cause inconvenience to somebody, then you commit the tort of abuse of legal procedure. Now, what is this abuse? It is called malicious prosecution. Let's understand what is malicious prosecution and let's understand the details of the same. Let's understand what is malicious prosecution. Malicious prosecution consists in instituting unsuccessful criminal proceedings maliciously and without reasonable and probable cause. So, what is malicious prosecution? It is instituting, that is, it is initiating or it's starting unsuccessful criminal proceedings. See, understand, malicious prosecution as a tort can only happen in cases of criminal proceedings, not in cases of civil proceedings. So if you start civil proceedings against somebody unsuccessfully, you or maliciously, you will not be entitled to file a case of malicious prosecution. It is limited to the case of criminal proceedings. Now they have to be unsuccessful and done maliciously, that is without any reasonable and probable cause. Malicious and reasonable and probable cause are different categories. We will understand them. So you do not have a reasonable or probable cause to initiate proceedings and you do it maliciously. When such prosecution causes actual damage to the party prosecuted, it is a tort for which he can bring an action. Now, when there is an actual damage caused to the party, we've all already understood the most essential part for a tort to take place is damage. You have to prove damages, then it is a tort. The law authorizes persons to bring criminals to justice by instituting proceedings against them. You have the right to bring criminals to justice, you have the right to have justice. If this authority is misused by somebody by wrongfully setting the law in motion for improper purposes, the law discourages the same. So if you unsuccessfully do this or you do this wrongfully, then law will have a discouraging you. Law will have a discouraging effect. It has punishments for you also then. To prevent false accusations against persons, innocent persons, an action for malicious prosecution is permitted. So to have this malicious prosecution is permitted. In the case of Abrath versus N.E. Ray, it was held, in an action for malicious prosecution, the plaintiff has to prove. What does he have to prove? First, that he was innocent and that his innocence was pronounced by the tribunal before which the accusation was made. First, you have to prove that you are innocent. How are you innocent? The law, the judicial system has to prove you to be innocent. That is, you are acquitted in such a case. Okay. Secondly, that there was want of reasonable and probable cause for prosecution, or as otherwise stated, that the circumstances of the case were such as to be in the eyes of the judge inconsistent with the existence of reasonable and probable cause. That is, there was no reasonable and probable cause for the other person to institute the case. And lastly, the proceedings of which he complains were initiated in a malicious spirit, that is, from an indirect and improper motive and not in furtherance of justice. That you did not do it for a proper cause. You had some evil motive in your mind. Now, what are the essentials to institute a suit for damages for malicious prosecution? That the person was prosecuted by the defendant. That is, you set into motion a prosecution. We will have to understand what is prosecution. Now, the prosecution was instituted without any reasonable and probable cause. That is, you did not have any reasons to believe that what you are doing is correct. Then, after that, the defendant acted maliciously and not with a mere intention of carrying the law into effect. So you acted maliciously, you had ill motive or ill evil in your mind. That the proceedings were terminated in the favor of the present plaintiff. That even after doing all this, the court acquitted you. You were held to be innocent. And because of all this, you have suffered, that is, the plaintiff has suffered a damage as a result of the prosecution. So damage has to be proved. Now, the first essential, let's see what is a prosecution. So the essential elements require two proofs. What are those two proofs? That there has to be a prosecution. So first there was a prosecution and it was instituted by the defendant. There might be a prosecution not instituted by the defendant. Then in that case, you are not liable. You cannot bring a case for malicious prosecution. Okay. Now, it should be a criminal prosecution rather than a civil prosecution. I've already told you, prosecution means civil proceedings against a person in the court of law. So you have initiated criminal proceedings in the court of law against a person. A prosecution is there when a criminal charge is made before a judicial officer or a tribunal. Always remember, there has to be a judicial or a quasi-judicial authority which is there, which makes those charges. That is when you say it is a prosecution. Now, proceedings before police authorities is no prosecution. They cannot pronounce judgments. Police authorities do not pronounce judgment. They investigate. Okay. Now, proceedings before the police authorities are proceedings anterior to prosecution. That is, even before prosecution happens, they are there. In the case of Narendra Nath Ray versus Basant Das Bairagya, after a theft has been committed in the defendant's house, he informed the police that he suspected the plaintiff for the same. Now, he only showed a suspicion to the police that he suspected somebody. Thereupon, the plaintiff was arrested by the police but was subsequently discharged by the magistrate, as the final police report showed that there was no evidence connecting the plaintiff with the theft. Now, if I tell the police that I have a suspicion on so and so person and the police investigates it, and after investigation, if there was no evidence, then in such a case, there is no malicious prosecution. Why? Because there is no judicial authority. There is no charge made against you. It is mere investigation which has happened. There is no prosecution or proceedings which have been initiated against you. So, in a suit for malicious prosecution is what it was held that it is not maintainable because there was no prosecution at all, as mere police proceedings are not the same thing as prosecution. They are merely investigations. Now, when does the prosecution commence? Prosecution is not deemed to have commenced before a person is summoned to answer a complaint. Okay. Now, before you are summoned, only during course of investigation, it is not prosecution. In Khagendra Nath versus Jacob Chandra, it was held. Now, what was the case first? There was mere lodging of statement alleging the plaintiff wrongfully took away the bullock cart belonging to the defendant and requested that something should be done. Now, I file a statement to this effect. The plaintiff was neither arrested nor prosecuted. It was held that merely bringing the matter before executive authority did not amount to prosecution, and therefore the action for malicious prosecution does not lie. You only brought a matter to somebody's information. No arrest was made, no prosecution happened. There was no commencement of prosecution when a magistrate only issues a notice and not a summons to the accused upon receiving a complaint and subsequently dismisses it after hearing both the parties. So you hear both the parties and you dismiss it. There is no decision as such. Okay. The proceedings before a quasi-judicial authority can also be prosecution. In the case of Kapoor Chand versus Jagdish Chand, the Punjab and Haryana High Court held that the proceeding before the boards of Ayurvedic and Unani system of medicines, Punjab, amounted to prosecution. Why? Let's see. Here, a complete investigation and all took place. The appellant made a false complaint that the board of Ayurvedic Unani medicine, alleging that the respondent who was practicing as a Hakim was illiterate and had obtained fictitious certificate of hikmat by the underhand means, that is illegally. The board held that the respondent was admittedly a qualified Hakim and authorized to practice. In such a case, the malicious prosecution was allowed and compensations were given. Okay. Prosecution should be instituted by the defendant. The defendant himself should institute. Now, instituted by the defendant means there should be active involvement of the person in the cases of the malicious prosecution. So, a prosecutor is a man who is actively instrumental in putting law in force for prosecuting another. Merely showing suspicion or merely saying I have a doubt on somebody is not prosecution. All the criminal proceedings are conducted in the name of state, but for purposes of malicious prosecution, a prosecutor is a person who instigates the proceeding. There has to be instigation. A person cannot be deemed to be a prosecutor merely because he gives information of some offense to the police. I give some information, I will not be a prosecutor. If I keep on taking somebody's name and showing that, see, this person is doing this person is doing this, see, and I become instrumental there, then I can be held liable for malicious prosecution. The mere giving of information, even though was false to the police, cannot give cause of action to the plaintiff in a suit for malicious prosecution if the defendant is not proved to be a real prosecutor by establishing that he was taking active part in the prosecution and that he was primarily and directly responsible for the prosecution. So if I go and say, no, I am sure that X has done the theft and I will bring you proof and I will do this, I will do that, and I'm after X, then I will be liable. If I just say I have a suspicion on X and I do not take part in the entire process, then I will not be liable. Prosecution should be instituted by the defendant. Dattatreya Panduranga versus Hari Keshav. The defendant lodged a first information report to the police regarding theft at his shop, naming the plaintiff, his servant, as being suspected for the theft. After this, a case was registered and investigations were started. The plaintiff was arrested and remanded by the magistrate to police custody. On investigation, the police did not find sufficient evidence against the plaintiff, and at the instance of police, bail bond was cancelled and the accused, that is the plaintiff, was discharged. And the plaintiff sued the defendant for malicious prosecution. It was held that the essential element for such an action, that the plaintiff had been prosecuted by the defendant, it could not be established. The defendant had done nothing more than giving information to the police, and it is the police who acted thereafter. The defendant could not be deemed to be the prosecutor of the plaintiff. So you only raised a suspicion. You did not actively go after that person, be after police that you do this, do that. There was no ill intention. See, it's malicious prosecution. By ill intention, you do something. So you did not have any malicious thing here. Okay? That is why no case of malicious prosecution. Now, in order that a private person can be termed as a prosecutor for the purposes of liability for malicious prosecution, he must have done something more than merely lodging the complaint with the police for some defense. So you must be instrumental, actively instrumental in the proceedings, and must make his best efforts to see that the plaintiff is convicted for the offense. You lay down things, you plant things. That is what is malicious prosecution. See, always remember, malicious is ill will, evil motive. In the case we read right now, Panduranga case, there was no ill motive or ill feeling. If some theft happens and if the police asks you, why do you have suspicion, you will take names. But there is no ill motive here. Okay? How do you ascertain ill motive? You look at the facts of the case. Now, in the case of Gaya Prasad versus Bhagat Singh, the Privy Council pointed out that the conduct of the complainant before and after the complaint has to be seen to decide whether he is the real prosecutor or not. Right? I said conduct shows your malice. Okay? If the complainant knowingly that the charge is false tries to mislead the police by procuring false evidence for the conviction of the accused, he would be considered to be a prosecutor. Now, in case you mislead or if you push the police to do something which ordinarily the police would not have done, then it will be malicious prosecution. Absence of reasonable and probable cause. Now, second is that you do not have a reasonable and probable cause. The plaintiff has to prove that the defendant prosecuted him without a reasonable and probable cause. The reasonable and probable cause have been defined as, now how do you define reasonable and probable? An honest belief in the guilt of the accused upon a full conviction, now full conviction of the person who we are talking about, okay, founded upon reasonable grounds of the existence of circumstances which, assuming to be true, would reasonably lead any ordinary prudent man placed in the position of the accused to the conclusion that the person charged was probably guilty of the crime imputed. So there has to be an honest belief founded on reasonable grounds that any person, ordinary prudent person in the same position, would also come to the same conclusion that yes, so and so person has done the wrong. If that is the case, it is reasonable and probable cause. There is a reasonable and probable cause when the defendant has sufficient grounds of thinking that the plaintiff was probably guilty of the crime imputed. You have reasonable grounds. There is reasonability and sufficient grounds to prove that the person was guilty. The prosecutor need not be convinced as to the guilt or maintainability of the criminal proceedings before he files the complaint. But he only has to be satisfied that there is proper case to approach the court. So you should not be, it need not be 100% conviction. Okay? It need not be 100% conviction. Then, thus, neither mere suspicion is enough, nor has the prosecutor to show that he believed in the probability of confusion. So, mere conviction, mere suspicion is also not reasonable, and 100% is also not required. There has to be some reasonability. A reasonable, prudent person, an ordinary man in those circumstances would also think that so and so person can be guilty. If there is reasonable and probable cause for prosecution, malice is immaterial because existence of a reasonable and probable cause in the plaintiff's mind is a sufficient defense, right? If you have a reasonable and probable cause, you will not be able to, the other person will not be able to build a case of malicious prosecution. Now, like I said, the existence of reasonable and probable cause need not be 100%. Whether there is a defense is a question of degree. To what extent did you believe it to be reasonable and probable cause? That will depend on the degree. It is a subjective question. Now, the question is not whether the facts believed by the prosecutor are true or not. It is not whether you believed it to be true or not. It is whether the prosecutor honestly believes in those facts. That is, you honestly believe in the fact. The defendants can claim to be judged not on real facts, but on those which he honestly and however erroneously believes. If he acted honestly upon fiction, he can claim to be judged on that. So whatever facts are in front of you, if you honestly believe them, that is more than enough. Mere honest belief is also not enough. It is necessary that in that honest belief also you should act like a reasonable and ordinary prudent man. Okay? So it is both subjective and objective. Objective in the sense that, subjective in the sense that whether you believe it to be reasonable, true or not, honest or not, and objective in the sense that whether you acted like an ordinary, reasonable, prudent man or not, whether you're being too sensitive, whether you're overthinking, whether you're not being reasonable, that has to be seen. Now, the prosecutor should honestly believe in the story on which he acts. And in believing the story, he must act like a reasonable, prudent man. So you must reasonably believe in the story and you must act like a reasonable, prudent man. It has to be seen whether there was a reasonable and probable cause for any discreet man to make the charge complained of. So if any reasonable man would also do it, you are also reasonable enough then. The belief of the accuser in the charge which he is leveling must be based on the grounds which, or some of which, are reasonable and arrived after due inquiry. So you have to have some basis for the charges that you level. Okay? The prosecutor's belief should be based on due inquiry. There has to be some investigation or some application of mind here. He need not find out whether there was a possible defense to this prosecution. Now, what happens if you act on the advice of your lawyer or your counsel? It is a presumption that then you have a reasonable and probable cause. If advice of competent counsel has been taken before launching the prosecution, it is difficult to establish lack of reasonable and probable cause. Acting on the lawyer's advice is a good defense. However, the lawyer should be fully and fairly acquainted with all the relevant facts within the defendant's knowledge. You cannot take an opinion from a lawyer on half facts. If you do that, you will not be. There'll be malice then, because you have hidden some facts. Absence of reasonable and probable cause should be proved, and the same cannot be inferred from dismissal of the prosecution or acquittal of the accused. Merely because you were acquitted does not mean that there was no reasonable and probable cause. Okay. However, the charge is false to the knowledge of the prosecutor, or where the falsity could be discovered by reasonable care, innocence of the accused may lead to the inference of absence of probable and reasonable cause. Okay. So if you already know that the charge is false and the falsity, that is, it is false, could be discovered through reasonable care, then you are not having reasonable and probable cause. There's absence of it. Like in the earlier slide, we read that there has to be a little due inquiry. You cannot randomly level charges and say, in that spur of moment, I thought that this is the truth. No, that will not work. Now, otherwise, as a general rule, innocence does not prima facie show want of reasonable cause was described in the following manner. Okay, so innocence need not show that there was want of reasonable care. For example, when the prosecutor must know whether the story which he is telling against the man whom he is prosecuting is false or true. In such a case, if the accused is innocent, it follows that the prosecutor must be telling a falsehood and that there must be want of reasonable probable cause. Okay. Now, if you should know whether it's true or false, and if you do not ascertain it, that's one case. Or if the circumstances proved are such that the prosecutor must know whether the accused are guilty or innocent, if he exercises reasonable care, it is only an identical proposition to infer that if the accused is innocent, there must be want of reasonable and probable cause. Except in cases of that kind, it is never true that mere innocence is the proof of want of reasonable and probable cause. Merely because you're innocent does not mean that you have reasonable and probable cause. It must be innocence accompanied by such circumstances as raise the presumption that there was a want of reasonable probable cause. Now, the next is malice. What is malice is very essential to understand, especially in this case. It is also for the plaintiff to prove that the defendant acted maliciously in prosecuting him. That is, there was malice of some indirect, illegitimate motive in the prosecutor, and the primary purpose was something other than to bring law into effect. So, your primary motive was not to bring law into effect. Your primary motive was to cause injury, damage to the plaintiff by instituting the process of law. Okay, if the defendant is actuated not with the intention of carrying the law into effect, but with an intention which was wrongful in point of fact. So you had no purpose to bring law into effect or to bring justice, but you wanted to do wrong to the plaintiff. Malice means the presence of some improper and wrongful motive. That is to say, an intent to use the legal process in question for some other than its legally appointed or appropriate purpose. So you have a wrongful motive, evil motive or improper motive. That is malice. Apart from showing that there was absence of reasonable and probable cause, it is also to be proved that the proceedings were initiated with a malicious spirit, that is, from an indirect and improper motive and not in furtherance of justice. So, merely because something does not have a reasonable and probable cause need not be something that is malicious. You have to prove both. The prosecution must have been launched with an oblique motive only with a view to harass the plaintiff. Your motive should be evil. Okay, it means a wish to injure plaintiff rather than to vindicate law. You do not wish to get justice, you just want to injure the other person. It is, however, not necessary to prove hatred or enmity for establishing malice. Pure hatred and enmity is not essential to be proved. Mere fact that you wanted to wrongfully injure the other person is enough. Okay. Moreover, if the first information given by the defendant to the police is based upon the defendant's own knowledge and information given by his brother and two eyewitnesses, the fact that there was existing enmity between the plaintiff and the defendant cannot lead to the conclusion that information given must be actuated by malice. That is, if you give that information on true things, even if there was enmity, it need not be malice. Absence of reasonable and probable cause does not necessarily mean existence of malice. I have said this already. Merely because you had no reasonable and probable cause does not mean that you had malice. A person may be stupid or careless and may not take proper care to inform himself of the true facts. That may show absence of reasonable and probable cause for prosecution. And yet the defendant may not be acting properly. Somebody may not take due care to investigate and inquire and make a case, okay? But he may have no intention to hurt you or wrongfully do anything to you. He may actually be acting to meet the ends of justice, okay? He may not have a reasonable and probable cause, that is something else. Absence of reasonable and probable cause and existence of malice have to be proved separately. I have already discussed this once, that they have to be proved. Okay. Absence of reasonable and probable cause does not necessarily mean presence of malice, and similarly, presence of malice does not imply that there was a want of reasonable and probable cause. Moving on to understand malice, a person may be actuated by malice and yet may have a reasonable and probable cause. So having a reasonable and probable cause is in fact in itself a defense. So malice will then not be checked, okay? Because you have to check mark all three. Next. That is all three essentials. Malice has been kept separate from lack of reasonable and probable cause because, however spiteful an accusation may be, the personal feelings of the accuser are really irrelevant to its probable truth, and malicious motives may coexist with genuine belief of the guilt of the accused. So if you have a reasonable and probable cause, malice will not come into question. Prosecution does not become malicious because it was inspired by anger. Acquittal of a plaintiff is no evidence of malice. Merely because you had anger, there is no malicious prosecution if you had a reasonable and probable cause there. Okay? And if you have acquittal, that does not show a malice. Okay? Merely because the plaintiff was ultimately acquitted, he cannot sue for malicious prosecution. You have to prove that it was without any probable cause and malicious. Okay? Some of the items of evidence usually relied on for proving malice are haste, recklessness, omission to make due and proper inquiries, spirit of retaliation, and long-standing enmity. Now, these are probably hints to show malice, but need not be true. Okay, not every time a haste or recklessness shows malice. Okay, it may show want of reasonable and probable cause. Okay, omission to make the proper and due inquiries may be actuated or accentuated by malice, but may also show lack of reasonable and proper care. It is not necessary that the defendant should be acting maliciously right from the moment the prosecution was launched. It is not necessary that it was from the beginning that it was malice. If the prosecutor is innocent at the beginning but becomes malicious subsequently, the action for malicious prosecution lies. So initially that person thought genuinely, honestly, with reasonable probable cause that you are wrong somewhere. In between, that person understands that you're not wrong and this is happening wrong, but still he does something out of ill will or evil motive to keep the prosecution running. Then that is at that point the malice starts. If during the pendency of criminal prosecution, the defendant gets positive knowledge of the innocence of the accused, from that moment onwards, the continuance of prosecution is malicious. Now, the termination of proceedings should be in favor of the plaintiff. This is the next essential. It is also essential that the prosecution terminated in favor of the plaintiff. That is, the plaintiff was held to be innocent in the entire proceeding. If the plaintiff has been convicted by a court, he cannot bring an action for malicious prosecution, even though he can prove his innocence and also that the acquisition was malicious and unfolded. If you're convicted, there is no case for malicious prosecutions. The proceedings are deemed to have terminated in the favor of plaintiff when they do not terminate against him. That is, when it is not against him, then it is in favor. Thus, the proceedings terminated in favor of the plaintiff if he had been acquitted on technicality, conviction had been quashed, or prosecution has been discontinued, or accused is discharged. In any of these cases, you are innocent. Position where no appeal is possible. Where there is no provision of appeal against the decision of the court, the action of malicious prosecution would not be affected by the fact that if an appeal would have been allowed, the conviction or acquittal would have been reversed. Okay, the decision is final. Whatever decision happens, it's final. No action can be brought where the prosecution or proceedings are still pending. So, for example, if today some person is convicted or acquitted, for example, acquitted, and they bring an action against the other party for malicious prosecution, but that party has applied for appeal, the proceedings are still pending. They are not final. It is a rule of law that no person shall be allowed to allege of a still pending suit that is unjust. So if it is pending, you cannot say it is unjust. Finality has to be achieved. Last, there has to be some damage. Okay, it has to be proved that the plaintiff has suffered damage as a consequence of the prosecution. There has to be some damage. Even though the proceedings terminated in favor of the plaintiff may have suffered damage as a result of prosecution. Damage is the gist of the action. In Muhammad Amin vs. Joginder Kumar, the Privy Council held to find an action for damage for malicious prosecution based upon criminal proceedings. The test is not whether the criminal proceedings have reached the stage at which they have been correctly described as prosecution. The test is whether the proceedings have reached a stage at which damage to the plaintiff has resulted. So basically, damage is the essence. Damage is also the essence of tort, because we've already studied that tort aims to bring back the person into the original position. The lordships are not prepared to go as far as some courts in India in saying that the mere representation of a false complaint which seeks to set criminal law in motion will per se found an action for malicious prosecution. Privy Council says this is not a right approach per se, and there has to be some damage which has to be shown. It was observed by Chief Justice Holt that threefold damage may be caused to the plaintiff as a result of prosecution. Now, what are these three folds of damages? First, damage to a man's fame is as if the matter whereof he is accused is scandalous. So, first is fame. Then damage to the person, as in where the person is put in danger to lose his life or liberty. So for example, if because of the malicious prosecution you're put behind bars. So 2%. And damage to his property, as where he is forced to expend his money in necessary charges to acquit himself of the crime where he is accused. So in case he is accused, he will have to hire lawyers, he will have to use a lot of money to prove himself to be true. That is in terms of property. So, for the claim of malicious prosecution, the plaintiff can thus claim damage on the following three counts: to his reputation, to his person, and to his property. Any damage to either of the three, one of the three, two, three, whatever it is, you will be entitled to bring a case. Now, a false charge of a criminal offense obviously injures the reputation. So, if there's a false charge, you injure the reputation of other. Apart from that, damage to the person may result when a person is arrested and deprived of his liberty, and also when there is mental stress on account of prosecution. So your person is damaged and your property is damaged, where as a person who is prosecuted has to spend money for his defense. So these are the three categories of damages. In assessing damages, the court to some extent will have to rely on the rules of common sense. Over and above, the court will have to consider the following four factors. What are those four factors? The nature of the offense which the plaintiff is charged of, the inconvenience to which the plaintiff has been subjected, the monetary loss, and the status and position of the person prosecuted. In all these cases, what kind of charge? Is it a very grave charge of murder, okay, or a simple charge, okay, of probably public nuisance? Then, what was the kind of inconvenience? In case of murder, were you put behind the bars? In public nuisance, were you called repeatedly to the police station to question? Monetary loss, what kind of money did you spend? And what kind of status and reputation the person has in the society will also show the kind of loss he has of his reputation. Failure of prosecution is not necessarily detrimental to a man's reputation. Now, failure need not necessarily be detrimental to the man's reputation. In cases of compensation, let's see what kind of compensation the court looks at. Shiv Shankar Patel versus Fulki Bai. In this case, there was a prosecution related to theft of crops before the criminal courts. And evidence led before the criminal court clearly revealed that the crops harvested from the disputed lands were stolen by the respondents. Evidence was also established that the agricultural land also belonged to the husband of the respondent, and this remained unrebutted. Prosecution ended in acquittal, so there was no conviction. The innocence was proved. Prosecution can be said to have been launched not with the intention of carrying law into effect, but the intention which was wrongful in point of fact. The respondent also faced criminal prosecution for 8 years and lost reputation in the society and also suffered mental agony. All this proves that there was malicious prosecution and 10,000 rupees was granted as compensation. Now, law is settled. In a case of damage for malicious prosecution, onus of absence of reasonable and probable cause is on the plaintiff. So the plaintiff has to prove there is absence of reasonable and probable cause. But this is qualified to the extent that in case where the accusation against the plaintiff purports to be in respect of an offense which the complainant claims to have seen him commit, and the trial in the criminal case ends in acquittal, the presumption would be that not only the plaintiff one is innocent, but also there was no just and reasonable cause. That is, that if you prove the so and so, then there will be no reasonable and probable cause. Otherwise, the plaintiff has to prove there was no reasonable and probable cause. Now, there is a distinction between false imprisonment and malicious prosecution. Why false imprisonment? Because there also you might restrict a person. In malicious prosecution, if you put the person in jail, there also you might be restricting the person. In malicious prosecution, imprisonment is procured by a judgment or an order of the court or by a judicial order. In unlawful arrest or imprisonment, that is false imprisonment or detention of the plaintiff has been made by a private individual or procured merely through a merely ministerial officer of law rather than a judicial officer of the court. The wrong is of false imprisonment. So if it is by court order, it is what? It is malicious prosecution. If it is by ministerial persons or by a private person, it will be a false imprisonment case. Then, this was greatly described by Justice Wills, and he also stated this only, that if it is by a court order, it will be a malicious prosecution, and if it is by it is by ministerial officer or by any other such person, it will be a case of false imprisonment. The second distinction is that false imprisonment is prima facie a tort and prosecution is not. Therefore, in an action for false imprisonment, it is the defendant who has to justify the imprisonment. However, in a case of malicious prosecution, the plaintiff has to show that there was no reasonable and probable cause. Now, in an action for malicious prosecution, the plaintiff has to prove the malice on the part of defendant. In false imprisonment, the requirement is not there, and it is therefore no defense to say that the detention by the defendant was without malice and due to bona fide mistake. Okay. I've already stated this, that there are no malicious civil proceedings. There are no malicious civil proceedings. Unlike malicious criminal prosecution, no action can be brought as a general rule in case of civil proceedings, even though they are malicious or have been brought without a reasonable cause. So, if they are malicious or they have been brought about without any reasonable cause, then also you cannot bring an action. Since an unsuccessful plaintiff in any civil proceeding has to bear the cost of litigation, it is considered to be sufficient deterrent, which may discourage false civil proceedings. Whoever loses bears the cost. So here that is considered to be a deterrent. In exceptional cases, however, where the cost of litigation may not adequately compensate the defendant, he can sue to recover damages arising out of loss from the civil proceedings. Okay, now if in those cases also, if you are unable to recover the cost, you may bring in a case of recovery for damages. Such examples of proceedings can be insolvency against a businessman, winding up proceedings against a trading company, proceedings which result in arrest or execution against the defendant's property or his attachment. In such cases, you can also recover damages. Now, the essentials required to prove in such an action were stated in the case of Genu Ganpat versus Bhalchand. In order to succeed in establishing malicious abuse of civil proceedings, the plaintiff has to prove a number of ingredients. What are these? First, you have to prove malice. Second, the plaintiff must allege and prove that the defendant acted without reasonable and probable cause and the entire proceedings terminated in his favor or process complained of has been suspended or discharged. And the plaintiff must also prove that such civil proceedings have interfered with his liberty or property, or that such proceedings have affected or are likely to affect his reputation. For example, if the civil proceeding have resulted in arrest of the person, or if they are the nature of bankruptcy proceedings, winding up proceedings, they may adversely affect the person's reputation, and then you can bring an action for damages because you have to establish that you have suffered damages. Now, there's another kind of proceedings where you give money to somebody else to carry on litigation. These are called maintenance and champerty. What are they? Maintenance is aiding a party in civil proceeding by pecuniary assistance or otherwise without a lawful justification. So I give money to somebody to carry on legal proceedings. They are both a tort and a crime. The essence of the offense is intermingling with litigation in which the intermingler has no concern. This is also called third party funding. Somebody funds litigation. Now, right now, the position we are talking of is in England. We will also study the position in India. Champerty is a species of maintenance in which the person maintaining is to have by agreement a portion of the gain made through the proceedings. So, if the proceedings succeed, the person will get a part of it. The maintained proceedings should be without any justification. It is, however, no defense to say that the maintained proceedings were successful and hence justifiable. So, there has to be no justification for this. Common interest of the defendant with the party assisted is a good defense to an action for maintenance proceedings. So, if you have common interest, for example, there is a wall over which you're fighting, a boundary wall, and the third party has a common interest, then you cannot call it maintenance. A common interest, generally speaking, may be justifiable, that which would otherwise be maintenance. So it will justify what would be maintenance. But the common interest must be one of a character which is such that the law recognizes. So law legally recognized common interest. Such interest is held to be processed. When in litigation, a master assists his servant, or servant his master, or help is given to heirs or relatives or to a poor man out of charity to maintain a right which he otherwise would lose. So in these cases, there will be no maintenance, that you're not third party funding to cause problem. Okay, you're just helping. The common interest should be some legal matter in the suit rather than a sentimental or aesthetic interest. You should have an interest in the legal matter. Professional legal assistance by counsel and solicitors to poor may be permitted when there is a proper cause of action. And these are all legal aid pro bono cases, okay? In an action for maintenance, the plaintiff has got to prove that he has suffered damage by maintenance of the other party. So you have to prove because the third party was funding and fueling, you have caused some damage to you. Now, the English law is not in force as specific laws in India. The Privy Council expressed that a fair agreement to supply funds to carry on a suit in consideration of having a share of property, if recovered, ought not to be regarded as per se opposed to public policy, and in some cases, it would be in furtherance of right and justice and necessary to resist oppression. Okay. Now, in such cases, they have been allowed. However, in Ram Kumar versus Chandrakanto Mukherjee, such agreements are found to be extortionable or unconscionable so as to be inequitable against the party, or have been made not with the bona fide object of assisting a claim believed to be just or of obtaining a reasonable recompense thereof, but for improper object, as for the purpose of gambling in litigation or for injuring or oppressing others by abetting and encouraging unrighteous suits, so as to be contrary to public policy, ought not to be given effect to such agreement. So in cases you are helping third party funding or you are taking some gain, and if they are to extort or are for improper or against public policy or to cause damage to others, such agreements cannot be given effect to. Okay, so this was about maintenance and champerty. Basically, an agreement between people to sue a third party, you fund somebody in litigation, that can also be questionable as a tort and as a crime.